objecting to offending paragraphs in the witness statement of Johnson Asiedu-Nketia, the General Secretary of the National Democratic Congress, on whose ticket the petitioner John Dramani Mahama stood as his presidential candidate to contest the December 7, 2020 elections. Out of 10 offending paragraphs, the court graciously admitted 3 of the paragraphs to remain, and 7 of the offending paragraphs were removed in part, but 1 of them was totally expunged from the witness statement. It is pertinent to state that 1 of the offending paragraphs related to the pedestrian allegation of Asiedu-Nketia and his witness statement that the chairperson of the Electoral Commission has a familial relationship with Her Excellency the First Lady of the Republic, Mrs. Rebecca Akufo-Addo. We all witnessed the strenuous and tedious submissions by petitioners' lead counsel to answer to the objections which had been raised to portions of the witness statement. It was a repetition after repetition, which prompted lead counsel for second respondent, who could not bear it any longer, to remind the court of the repetitions. When Mr. Johnson Asiedu-Nketia took to the witness box, he remained largely evasive. Every question that was posed, his immediate response is that I do not speak for the petitioner. This is someone who in paragraph 2 of his witness statement has stated clearly that he was in court to end or lend aid to the petition filed by petitioner. How can you come to court as a witness for a party, and when you are asked questions in court, your response is that I don't speak for the petitioner? Then why are you in that court? Why are you then in the court? He thinks he can be as elusive and evasive as he was in 2013. This time around, he will not be lucky. Now, it is very instructive to let Ghanaians know that the one person who filed the petition, which is John Dramani Mahama, has refused, failed, or neglected to sign onto a witness statement. As we address you this afternoon, the petitioner himself has no witness statement before the court. This is a petitioner who seeks to have the elections annulled and is praying for a rerun. This same person is refusing to come and give evidence in court. The judgment is with the Ghanaian public, not mine. When Johnson Asiedu-Nketia went all about town, he said one thing which is pregnant. When he was posed the question by lawyer for first respondent, his response was that we are in court to challenge the conduct and constitutional duty of first respondent. We are not in court to challenge the elections. That is Johnson Asiedu's own statement, not mine. We are in court to challenge the conduct and constitutional duty of first respondent, not the elections. So this is where we are. As I always do, I will allow you to ask questions, if any.
First question.
At the latter part of proceedings, you made a request, wanted to confront the witness with a certain video. We're just wondering how exactly does that help your side of the story? Because the contention that they have put in their petition in terms of what they have filed is to make the case that...
Can you repeat the question again?
Yeah, I'm saying that at the latter part of proceedings, your side put in a request for a certain video to be allowed so that you confront the witness with it. I'm only asking you to explain to us how relevant this is, in that the substantive matter that is before the court is the claim that no one had more than 50% of the votes cast, not the claim that no one won, like that someone won by more than 50%.
In court, the test for every witness in court is the witness's credibility. So you realize that when we went on and on and on, the final leg of the submission was that we want to attack the credibility of the witness. And it was at that point that the court was minded to grant the application for a play of that video. Now the relevance, to you it might not be relevant, but the relevance is that these are persons who after or during the course of the elections had proclaimed to Ghanaians. In fact, the presidential candidate himself, John Mahama, the General Secretary, Johnson Asiedu, the Deputy General Secretary, Otokuno, the Director of Elections, Visafi Ankra, and their communication officer, Sami Jenfi, had proclaimed to the whole of Ghana and the world that their presidential candidate had won the presidential elections, and they had secured, some were saying 140 seats in parliament, others were saying 141, others were mentioned that they were not even sure. And when they proclaimed that they had won the presidential elections, they gave you percentages. Don't pretend as if you didn't hear. They gave percentages. And some of them were calling the presidential candidate president-elect. I think I recall Sami Jenfi, their communication officer, referred to Mahama as the president-elect. Some of them even urged him to form a parallel government. Now when they are being invited to the police, there's another story. They advised him to run a parallel government because they had won the elections. Now these are the same people who now, when come to court, cannot even tell how many votes they garnered and are asking for a rerun. Does that sit well with you? And you think it sits well with Ghanaians? No. But you see, I must point out also that the exhibit that Asiedu was confronted with was their own exhibit. The exhibit E was their own exhibit. In his testimony, they failed to sign on to regions where it was abundantly clear that the petitioner had won elections there. Their agents in the strong room decided to take a long jump when they realized that the results proved unfavorable in their cause. That is my answer.
My question is in reference to the claim the remark that you said Mr. J0kers made in court. Indeed, what we heard him say was that he is not the petitioner and not that he does not speak for the petitioner. You are lawyers. When somebody says, I am not this person, it's different from saying, I do not speak for that person.
Have you read paragraph 2 of his witness statement? Maybe if you read paragraph 2 closely, on Monday when I come, we can have that engagement. But when somebody says that the petitioner stood on the ticket of the National Democratic Congress to contest the elections, and I, the General Secretary, the Chief Executive Officer of the party, I am swearing to a witness statement to give evidence in support of the petition filed by the petitioner. Would you still want to maintain your question?
Well, I just want a difference to know the difference between when someone says, I am not the petitioner and I do not speak for the petitioner.
A witness only corroborates the case of the party. You don't become a witness in court because you sprang up from somewhere, maybe from Mountain Kilimanjaro. You become a witness because there is a dictatorship party in the case. John Dramani Mahama has not donated a power of attorney to anyone to speak on his behalf. It is Johnson J0kers and Dr. Kwesa White who are coming to speak as witnesses. And they all state that they are speaking in support of the petition. So you cannot come to court and lend aid to a petition, and when you are asked questions in court, you say, I am not a petitioner. So what are you? Are they aware of something?
Okay. Thank you very much.
I would end as I always do. If you have nothing to say about another person, whether that thing is useful or beneficial, then please do not say anything at all. Because if you invariably say what you want to say, you will prompt the other person to also say something or respond in a way or manner that may or may not just otherwise be pleasant to you. Let's all be guided by fidelity to the truth and don't bear false testimony. Thank you.
For lawyer upon now on cases here. Lawyer.
You remember the tougher? Yeah, oh, say, everyone saw the assembly quota. And say, and some no nina pese court no. Ejitimuno. Udi nina betu court ne. Maybe sadia echini say, udi assembly ba ne chire no. Ubesi sawa no. Udi say ube surprise other party no. It can penisa. And it ube here Ura Mahama de assembly ba court no. And some bi oha okay. Nenso J0kers did a witness statement ni ba no. Ese oni bi wo na Mr. Mahama na nkasa ya ni case no. One fanship nekobasa na enye surprise ya one channel nko ani mum ukura mpo ya mouse ya me etwam sisi efi se ade ya machi eni so obi di na asema ba na ni witness eni na ji hu achinyi efi se ni witness ni kan no sonko efinia nipa na so de asem no ba no kan ti kabere etwam sisi na ye efi se enkiwie case ni e tra addresses a enkibi ensem e beta wo mra kwan so no e ma asem no kure betwam ntem enti bi say omoda yase ya ba sabre na ne ho biem ni se senia ensem ni course ne no bo se ensembusa no e ba no de se bi munyina mo court ho no hu senia no ye ne ko ye wie enti mi nkan kosi ase bebre na so ba bia ye de se ensembusa ne ba ye se ye mbra ye to aba ni wie ye no enifo bi e wo NDC mu ena Mr. Mahama nkasa former president omo kan se abane de Owura Mahama ena ewi ni
one touch
mi kuma me chia ne sisi asami jamfi nso kan bi se president elect na kono ye nanso na nipa bebre ehwe ni mu se nka Owura Mahama de case ba Supreme Court no obeka say yentwa abato num ura Kufuado wenwini ne momo ura no Mahama no na wini na ka yenka say Supreme Court enkansi so senior 2013 na Kufuado ba court so ekoye nwanwa say omo ba court no ura Mahama say wenwini ne momo ura Kufuado nso wenwini enti no eba ne saga yenkoto aba no mo mienu nya na gum ne akradonkom nya enfo mu sinchen enti ehọ ne just say enti o de tron semo a sebi ono ani na pamfo ekan ya e ma supporters bebrani giye eni be bi anka esese otimi kansi susampa mi wini ene bi a ya wia me no antimi ameka se mpo ya wia no na wanso antimi ameka se me na mi wini ye ne ya yebu mi bukata no eno ne ma krofo bebre adwum ye o na kakra nti ebi adwada ye bo video no ana tape na munyam be hebi atie bi na se bi munyam ye badwema na motimi di mani ni maso nyina abu ba bi ejina no no tie dama se
Good afternoon, ladies and gentlemen of the press. I want to start by letting you know that today was very eventful. And I'm sure when you watched the proceedings, you came up with the impression that the John Mahama team brought a solid case to the Supreme Court. In fact, when we filed the petition, it was being bandied about all over the place that our petition was empty, that it had not disclosed a reasonable course of action. Well, today was your answer. I am sure you saw vividly the evidence that was being led by the General Secretary. We have not yet concluded the hearing, and so I will not comment on the merits of what he said. But I'm sure you are all witnesses and you know that this is not an empty case. Now, let me correct one misrepresentation, very deliberate and gross misrepresentation that lawyer Frank Davis, my very good friend, has made this happen. He sought to give the impression that we came to court because we wanted a relief to the effect that His Excellency John Dramani Mahama be declared the winner of the election. I am sure, as ladies and gentlemen of the press, you have read our petition. Nowhere have we sought that relief from the court. What we have sought from the court is very simple and may be summarized in two. First, we want the unconstitutional conduct of Jean Mensah to be held to account. Secondly, we want the court to declare that none of the candidates met the threshold requirements of Article 63, Clause 3 of the Constitution. That is the crux of our case. And that is the case that we have sought to make in court today with the witness statement of the General Secretary of our party. Now, it is far from being the case that John Dramani Mahama himself must testify in this matter. He has filed a petition. He is entitled as of right under the law to call witnesses in aid of his case, and that is what he has done. In 2013, His Excellency Nana Addo Dankwa Akufo-Addo never testified. Ladies and gentlemen of the press, if you have evidence that His Excellency Nana Addo Dankwa Akufo-Addo testified, please bring it to us. He did not testify. He called witnesses to testify on his behalf. So is it the case that when it comes to His Excellency John Dramani Mahama, the law must change and compel him to testify? I am surprised that a senior lawyer of Frank Davis' stature is confusing petitioner with witnesses that the petitioner calls. Also, it played out in court today
that if we had done proper case management as we were pushing, we would not be where we were this afternoon. You remember we complained bitterly that case management, as stated in CR 99, was supposed to last 5 days. The court compressed it to 2 days, and in fact told us that we had spent the first day of those 5 days making the case for the interrogatories. Now it played out in court today. The importance of case management. When they sought to tender the pen drive that contained the so-called videos in which principal officers of the NDC and our presidential candidate made certain statements, you saw what happened. The court was not prepared to play that video because it had not anticipated that it will be needed, and there was no equipment in court for that purpose. As practitioners, we know that at case management that issue would have come up, and the court would have been prepared that on day 1 of the trial, a video will be played showing evidence of statements that our principal officers made. Ladies and gentlemen, it is very important for us as a party to understand the fact that we are not in this case because we want to joke with the Ghanaian people. At the end of the day, the issues of accountability, the issues of the mathematics of Article 63(3), and you very well, you saw it in court. When calculators were flying around, were we the ones who brought the calculators to court? Were we the ones who brought the calculators to court? But we warned you that this case, a big plank of the case, concerns the mathematics of Article 63(4), whether or not Nana Addo Dankwa Akufo-Addo, as a presidential candidate, crossed the constitutional threshold of more than 50% of the vote. Our case is that he did not, and we will prove that in court. Just watch out in the next few days. Any questions?
I just want to find out whether this has any impact on the case as you have put together.
No, we don't think it has any impact on the case we have put together. We are allowed to bring those matters back, when cross-examining their witness. So we don't think that it in any way, destroys our case or minimizes the probative value of whatever evidence we are bringing. But note that they raise the objections based upon the so-called scandalous nature of some of the averments or some of the statements in the witness statement. All right. Now, we had alleged that she acted in a biased manner, in an arbitrary manner, in a capricious manner that was motivated by personal dislike for His Excellency John Dramani Mahama, or if you put it in the converse, her likeness for Nana Addo Dankwa Akufo-Addo, her preference for Nana Akufo-Addo. And that is how come that in our witness statement we sought to make it abundantly clear that she had a familial connection to the Akufo-Addo family, that she is a relative of Her Excellency Rebecca Akufo-Addo. Now, if that is not material, what is? If you are a family, a relative of the First Lady, are you telling us that you don't want her to continue to be First Lady? So we said that she did it, with a predetermined agenda designed to continue, to let her sister or cousin continue to be the First Lady by announcing that Nana Addo Dankwa Akufo-Addo was the president.
So you have made it clear to us that the petitioner himself will not be in the box and that he has assigned witnesses to make his case for him. However, in court, at least more than 5 occasions, the petitioner's witness declared that he was not the petitioner and therefore did not answer certain questions that were thrown at him.
Well, that's an excellent question. It means that you are watching the proceedings. let me make it clear that in those instances where the witness said that he was not the petitioner, they wanted the witness to give evidence with respect to the state of mind of the petitioner. Okay? Anything attributable to knowledge that is within the personal, knowledge of the petitioner. I mean, how do you expect a witness to be able to testify to those matters? And that is how come that he legitimately declined to do so. It is not because he is distancing himself from the petitioner. In fact, he is not here under compulsion. He voluntarily agreed as our general secretary to testify because he is the chief administrator of the party. He coordinated with the help of the chairman and the other principal officer. He coordinated the election. So who better to testify on our behalf than our general secretary? And that is precisely what he was doing. But if you insisted that he should speak the mind of the petitioner, he should testify to matters within the knowledge of the petitioner, he would decline. And that was just as it should be. And in law, the general secretary was right in declining those questions. Any other questions? All right. Thank you very much, ladies and gentlemen of the press.
Okay, so let me just do the let me do the for your best friend Yatre and then the course the Supreme Court of Ghana mu ewutwi kasem na sakra na metre de Dr. Ayine aka no poto kasem wutwi kasem mu no Frank Davis oye kasamafo Emma the second respondent eye na nado danko ekufuado aka nsem bia ewo se yeyi ano na ma Ghana for anye sebio sa inkontumpu sem no antum yedi kan samutie ni a oyusu word bi say about 10 passages na ewo General Mosquito witness statement mu no omo ka say court no mu na court no bo mu sungu ye because sansem no a pedestrian chese sebio e yakushisem obisanfo mu nyina mo hwe de course wo court ni bi with TV so court no bo sa nsemfuanso na gu no court na nka ba bia se e pedestrian court na nka se yakushisem omu person ka court no bo sansem na gu because e yakushisem e scandalous the court na ntie the court no ka ya ne se wa bo sansem so no agu because say any your petition the dear friend of pleadings it has no foundation in the pleadings. That is different from some Obeka say and someone a war General Mosquito a dance crater muno a pedestrian. Now you pay attention and you raise this issue because of Bibi Mokasama second respondent Suban said maybe I be free court abahabiano or be you suka se and say be someone any say free a lawyer for ano e de akasa fa the course of court. The last time it was intransigent and now it was somebody who had a jaundiced mind and there will be a passage is here pedestrian ya best any dim say a lawyer for we are this year money atete e wo kwan ya wo se ya fa so kasa and it is a free court now what about the can someone akotwa the court can share court nano if the court in dismissing or upholding those 7 objections did not say pedestrian that conduct is unbecoming of a lawyer of the standing of Frank Davis. The best stress you condemn is enkoso because a bit me asemwa court no edi the atosubiem okasa Omampeni John Dramani Mahama ode na asema ba court or ye petitioner no onfa dance kata bia maaye enu nti no no kire se oni asem bia te se de doctor yi chechire mu opoto kasa mu no sa asem ne so eyemfuturu a ye nuanom etu ganafo ani because wo mramu no sa wo de wasem beto court anim se court nka wasema as petitioner bibia ni wa hya wo se e wo se wa obedi adanse ma ho emrane ma ho kwan se utimi fra dansefo ma adansefo ebedi adanse ma enu nti na in 2013 election petition no o mampenye kufu adode na asem as the petitioner no ono wa medi adanse ni bi wa ma obi aso mmra krata the power of attorney say o mejina nenam eya dansefo Dr. Bawumiamo and from mo be di adanse ma no enti de yewura John Mahama aye no edimu ewo mremu abiboni bi anim ti nsemu a ye nuanom kan ne no so no eni nyina so bia wo mrem ti be sese eno se beto ntwen ebiem okase NDC for emra ya to aba ni wie on 7 December ye ka kira wiase nyina se ye coalition ye nkonta ye bu kire se ya win election no but ye ba court no ye ka asem foforo se court no order for runoff na no kire se ye witness asedu ketia ne NDC for ye nya no kwafo obobo ye nyina ye di ne de keka ho abusiafo sa semi a ye nuanom NPP for aka ne he ya o maka ne bebi bebre no ye tende pa ne se ya semu a ye de aba court no omonti ase yenti a kasa ne se ya semu a ye de aba court no has got nothing to do with the coalition ayaye any ye figures ayewo wo mremu no se obi tia wo na so mpremu na wo the lawyer for friend two courses of action against the person who na obe choose the other aba court kane enti ampa ye press conference based on pink sheets ne results ayewo your coalition yaka say John Dramani Mohammed Nkunim. But as someone at the Abba court, and that is not the nature of it. As someone at the Abba court has to do with the constitutionality of the declaration. Yes, the constitution they say who declare be say when you mampeni abatwa. I was a sign the pakrono when ya emapanumu or homu chichemu do numi echiri. There in 70 figures wa would declaration mampeni kufuad wenya. Into we declaration it yaga namra kuni 1992 constitution. Not just a mremuno declaration doesn't even exist. So if the declaration doesn't even exist there, then issues about the coalition in the view of our lawyers so we have elected to challenge the constitutionality of the declaration of Jimensa. That is what is in court. At the appropriate time, say was said ye kasa about the coalition ya ni adanse ye ya we beka nwasem but let in some way ye kan about the course of court no ye man fa in some way that court nanim which is about Jimensa adwuma waye abato awabobo any whether or not to say edimu results are declare no edimu ewo emrem abusianfo ebiem omaka say oh Yewura Johnson na say du keti adanse mu no oka say he is not John Mahama the petitioner. Enti no no kire say Yewura say du ketie nim de oka na petition ni masem. O de ya ne say a lawyer fo a omunim de. Pa o mote sanse no yase no. E maybe e be fi court abia no maba no mutu fitu gu Ghana fo ani. Otie de fande bisankaza kan ya. O say paragraph 2 of Yewura ase du ketie dan secretary na wo say he's giving evidence in support of the petitioner. In support of the petitioner, that means I am giving evidence as the petitioner. What that means is as a witness, evidence or the support to petitioner in the case, what the lawyers will say matters within his personal knowledge. It is all babies and the question say now. Central for share movie as na John Mahama wo bia waje atum e ho no wanka se onye petitioner because I know the onim na baby say the questions fa petitioner no de ma ne kan bibi ana de na e woni timiti o ye bibi a make say someone who person o kan no they are not within his personal knowledge any on wanka se ni ndem to o man wa dance ye kra wa tomra that should show you say and na ye penyimu pa odi adanse no o ye no kwafo he's credible. Say in some way within the personal knowledge in Kwano Beka Wansen. Nabusian for Yeba the course of court in Muno. A course of court. The Moshe and some Bisabi break also say agents assign way, which new agents or Munio, which they said the general secretary can but the same way the Abba court has got nothing to do with that. Bobo Aba on 9 December. A catch Ghana for some Mapiku. We see total valid votes are Wujina so cast our reneno 30,434,574. Yekoye nkonta wan kasa wayan wo declaration ni mu a o man penye kufu adware per wan kasa wo figures percentage a wodi ama no enye correct as long as why say ya detachment south nyina ka ne ho a still candidate Mahama Nsan ne ho enye correct kwansi ma de achen ya na wasan so at the press release a do bi Nsan shase aba eno so total valid votes a wo de bu nkunta ka so man penyo fa do awe ne yesen a they say the 13,434,574 biem almost say 13,119,460 na figure na sa eno no maka cha magana fo nyina gie di so ma me ne yemfonso wa correct ne mfonso afeye Rajon Mahama e de asem we ba court ya se ma meji mensa be kire emmado do a wugina so di declare say Rajon Mahama renia correction na na ba renia correction oye no 10 December eno na Ghana fo mu nyina magie di say eno na real results no what atwe baby paragraph 12 and paragraph 24 of her answer to the petition. Also they say the figure no and yet 13,180,460 now can the 10th no now 13,121,111 there's the figures now yamiensa after your website also with the 275 constituency summary sheets ago obi abetimi akwa kofa na wakan ne wahu abato no nsunsanso ne ye kokeka sienia total valid votes ne yesen a eno so 12,218,633 because about to ba kwa ya to o results nko aburo na yechire dedia esesa na eno na Yewura Johnson say do ketia e ka ho asem say that is the issue before the court and we are saying say so wutie ma me nanka say no mu asem ni figures or the two dwa no na eno ne yesi ye de be ye adwuma dia ene eno ma penya kufuado enya more than 50% of the total valid votes enunti weni ikuni enti abusiofo de ne course so court in the court to ahye ejo da ye beba na Yewura Johnson na Sedun Ketia waba ababetoa na dance so na ye ba eno so de besi dia no ye ne mo ebedi hu komite na wase.
Thank you. You are going to
thank you very much, and that was the two press conferences held by the petitioners' side and that of the second respondents, and of course the case has been adjourned till Monday the 1st of February for cross-examination of the petitioner's witness, in this case the General Secretary of the NDC, Mr. Johnson Sedun Ketia, to continue. He was first cross-examined by a lawyer for the petitioner himself, Mr. J0kers, and then by a lawyer for the first respondent, lawyer Justin Amenuvo, and then Mr. Akoto Ampao, the lawyer for the second respondent, began his cross-examination but did make a request for a tape to be played. Facilities for that tape to be played were not immediately available, and the court has adjourned till Monday, and that's why we'll bring the coverage to an end. We'll return on Monday to bring you all the other details. Thank you very much for being a part of this coverage. See you on Monday.